Here is a very simple explanation of Marbury versus Madison. It all starts with the election of 1800. Thomas Jefferson wins the presidency, and many Democratic Republicans win seats in Congress. The Federalists, who had traditionally had the power, were terrified that the Democratic Republicans would undo what they had already accomplished. So as they were going out, they created the Judiciary Act of 1801, which created 16 new judge positions, which would be appointed by the outgoing Federalist President John Adams. He, of course, would appoint Federalists to these positions, and the hope was that these judges would do everything in their power to slow the Democratic Republicans down when they took office. The problem for the Federalists was they ran out of time. They were unable to complete all the paperwork and deliver it before Thomas Jefferson took over as president. So some of the paperwork would still needed to be delivered, and it was on the desk of James Madison, the new Secretary of State. James Madison, a Democratic Republican, refused to deliver the paperwork. One of the judges, William Marbury, who was supposed to receive a position from the Judiciary Act of 1801, sued Madison to make him deliver the paperwork. Because of the Judiciary Act of 1789, said the case had to go directly to the Supreme Court. So the case goes directly to the Supreme Court. It skips the lower courts because Madison is a federal official. The Supreme Court ruled on the case, and their ruling was this. It was a unanimous ruling, but it was written by John Marshall, the court's leader at the time. It said that Marbury probably should get his judge position. However, the Judiciary Act of 1789, which required the Supreme Court to rule on these cases, was unconstitutional. So by ruling the Judiciary Act of 1789 to be unconstitutional, this prevents Marbury from becoming the judge that he wanted to be. However, much more importantly, it established the idea of judicial review. It established the power that the Supreme Court can review actions taken by states, lower courts, Congress, the president, the executive branch, the legislative branch, etc., and determine whether those actions and laws follow the Constitution. They set a precedent that they have the power to cancel laws or other actions that are unconstitutional. And of course, that has been copied over and over again over history.